relevant or just circumstantial.
Yes.
In other words, right? So we know, because you kind of listed them out, you broke it up, and you listed out, these are the things we know so far.
Right.
Which in and of themselves become circumstantial evidence.
Right, right. They're all circumstantial evidence, and but what the reason the Maharajhdam, the Rabbi Shmuel di Modena, goes through them, with such detail, is that he wants to tell us that at a certain point you have to get to the realization that he lived in Salonika, in Greece. He was born 1506 to 1589, but his and he responded to people from all over the Balkans and Italy. But it's this part of the Ottoman Empire, and he goes through all the details just because it's such a complicated case. I think also maybe I'm reading in between the lines, but maybe it's also his concern about being portrayed as someone who's on the side of the wealthy of the wealthy victim of this burglary, so that he wants to say he doesn't want to be seen as one who says, just because it's a rich person and this someone whom I suspect is a thief, I'm going to take money from him. So he's trying to establish with cover all angles, that to say, even though I don't have witnesses, but the circumstantial evidence suggests from all corners that this man did this thing, right? Now, so what Rabbi Shmuel di Modena really talks about is eventually the responsibility of the judge to make sure that the justice is done. So he brings now a case that is mentioned in the Talmud. He says, I could analogize it, כאשר נרצה לדמות עניין זה, לההי עומדנה דמר זוטרה חסידה. There's a story of a rabbi by the name of Mor Zutra, and he was called Hasida, the pious. And in the case of Mor Zutra Hasida, a silver goblet was stolen from his host. He was staying by someone with his students, and a golden goblet was stolen, and they were looking for the thief. Right? Ushpiza, by the way, it's the same word as we use in Ushpizin in the Sukkah, and it comes from the same word as hospice. So hospitality. The one who was hospitable to him is the Ushpiz. So how did they find the thief of the silver goblet? When they were washing their hands for the meal, Mar Zutra noticed that one of the students dried his hands, used as a towel the garment of another student. Right? So he approached him, he confronted him, and he said, I think you're the thief. And the man said, why do you think I'm the thief? He says, because you have disregard for other people's property. And he denied originally, but then when they pressed him, he admitted that he was the thief, and they did find it with him. So you can say this is a hunch. We don't know that he has the goblet, but his behavior indicated that he is this kind of person who might be the thief. He says, I'm going to skip this one. It says, גם היה בידי לבטל האומדנות ההם, אלא ששמחתי על הדברים הקרובים אל השכל. He says, I could also, one by one, all the elements of the circumstantial evidence that I mentioned before, each one of them could be rejected individually or separately. אלא ששמחתי על הדברים הקרובים אל השכל. I want to rely on what makes sense, on the logical part of the argument. So again, it's the full picture. It's that's what we call it, a hunch or a gut feeling. That's what Malcolm Gladwell called blink moment. The that, if you're involved enough in maybe in criminal investigation, a detective, a judge, a lawyer, policeman, and you're honest, you realize, I know that man is lying. I think, probably some of you have it. It look like the rabbi's hunch, that when you ask someone how you're doing, and the way they answer, this congregant either has a problem at home, a problem with the community. This is a thing that just, it's that, and you have to just to pursue it until it comes out. Here. So here, this is important now. We're going back to the issue of checks and balances. He quotes here Harava Magid, the Magid Mishneh, which is a commentary on the Rambam. The Rambam that we mentioned before, Maimonides, that says that the rabbi could follow his hunch, right? The Dayan could follow his hunch and issue the verdict. He says, Hadayan yesh lo lahtoch hadin lefi haemet. The judge must pursue the truth. Ad she'amru bechama mekomot kafte ve'odeh. We find in several places that the Talmud says, and this is one of them regarding the goblet, that they had a suspect, so they captured and bound him, sort of like putting him in jail, basically, and eventually he admitted that he's the one he's the perpetrator. So this is called kafte ve'odeh. He's forced to admit. You squeeze this confession from him. So we know today, in modern time, you have situations where, the police or detectives would get a confession by force, and it's not true. But we're talking about a situation where they actually find the stolen object. But the Harava Magid says that we have a reservation. It's not all inclusive. En bekol bedin koach kazeh. Not every court is authorized to do that. Ela im ken haya bedin hashuv umuhzak bechokma v'chasidut. The bedin has to be a famous bedin, known to be wise and pious. So this is where we put the check on court, saying not everyone can do that, because otherwise we're going to have a case. But now that we have judges that are not necessarily experts, yesh lahush, we have to be careful. Shelo yeh kol echad la'asot derech kirtzono. Each one of them will do as he wishes. That's the argument of Harava Magid, right? It's a valid argument. Do you agree with that? With this argument that if you say the judge does not need to rely on witnesses, he could rely on his hunch, then you create sort of a dangerous situation where everyone can do whatever he wants?
Yeah, isn't that why we have jury?
In a way, yes. But if jury also is once the system has been in place long enough, then people learn how to manipulate the system. So lawyers are instructed on how to manipulate the jury, and the judicial system, on the other hand, tries its best to filter the jury. So we always have this back and forth between how much power we give the judges in order to make sure that the system works, and how do we make sure that, on the other hand, they don't have too much power and they become the main benefactors of the system. Beneficiaries of the system. ואני אומר, so Maharashdam, Rabbi Shmuel di Modena, rejects the concerns of the Magid Mishneh, and he says the Rashba, Rabbi Shlomo ben Adret, did not make any reservation. ולא דיבר על הדורות שעברו, אלא על הבאים, ויפתח בדורו. He says the Rashba did not make such distinctions. He said you can never encompass all details, and it's given to the judge to decide. Now, this phrase "yiftah bedoro" is a key phrase. I sent an email about it a while ago. I wrote an article about the authority of the Dayan. The full phrase is "yiftah bedoro, ki Shmuel bedoro." That Yiftah in his generation is of the same status as Shmuel had in his days, in his generation. Now, Shmuel and Yiftach are mentioned together in the pasuk, in the verse in Shmuel, but they were. You couldn't find two more, contradicting personalities. Shmuel was sort of a holy person, dedicated from birth. He had visions at a young age, and he was a prophet. He toured Eretz Israel, preaching and teaching, etc. And Yiftach was, the best way to describe was a lowlife, who, a reject, who was kicked out of home, and gathered a gang of mercenaries around him, and then went to wars in different places. Eventually, he was called by the people of Israel to conduct the war against the king of Ammon, who threatened them, and he made this famous or infamous vow that the first to come out and welcome him when he comes back from war will be sacrificed. And it turned out to be his daughter, right? It's a terrible story. Some commentators try to defend him, to say he didn't do it, but it seems like he did do it. But still, he was considered the judge. That means, and that's what the Rabbi Shmuel di Modena is referring to here. He says that there is a concept of the power of the contemporary judge. You have to give enough authority to your local or to contemporary judge, and to call it support your local sheriff. The same thing as support your contemporary sheriff, because if you don't give them this authority, if you constantly tell them, okay, let's go back, let's look at precedents, then you're going to have a lockdown where people are frozen in time. And not only that, each rabbi or judge knows the needs of the community. So it applies in all fields. It definitely applies when we have, for example, questions of bioethics or reproductive rights, or organ donation, etc. That you simply cannot rely on answers, responsa, which was written 200 years ago before this technology. 50 years ago, the technology was just making its first steps and very unreliable. So you cannot rely on precedents. You have to create the halakha as you go along. But Rajhdam says it also applies to monetary issues, to financial issues, because here it says if you follow the letter of the law, the victim remains victimized. He lost his money, and someone is out there with this huge amount of money, and it says it seems that this is the person. So he says, I have to explain the words of the Rav Magid, who said that you have to have an expert bedin. He says, Kol echad lefi doro. You have to go to the leading court of your time. Be'ofen shelo yeh kol echad pores. You're right. You don't want to just pick up 3 people from the street and say you will be the court. But once you have, it's sort of a question of, we could say, tenure and reputation. That after a while, the bedin gets that reputation, that status of this is a reliable bedin. They do not abuse their power. They do care for the people. And v'chasher yaseh din ze bichnufia. When this judgment or this process will be done bichnufia, meaning being together. This, by the way, don't use this word in modern Hebrew today, because in modern Hebrew the word knufia. Did you ever hear this word, knufia? Knufia means gang in a negative way. It's like the mafia, or gang of criminals called knufia. It actually comes from the word kanaf, wing, to be under one's wing. But it's an Aramaic word. Knufia means to be together. So it says if everybody's together, the judges, hamevorarim, the known judges, and they add 2 or 3 more of Mehachim Me'ainim. So he says, yeah, let's be cautious. Let's not. I don't want to decide on my own. So let's take the Dayanim Mevorarim, the one who are appointed. That's Mevorar, means chosen, elected, like Bahar, Barar, and add 2 or 3 of the Me'ainim, of people with analytical skills. And when everybody agrees, then this is what we have to do. Now he finally gets the verdict. So let's say, what would you say if you would have the case? What would be the verdict that you would issue in that case of that man who is a suspect because of circumstantial evidence? You'd like to say, no, you'll be the judge. What would you say we should do?
It happens in America all the time that people are convicted even of criminal cases on circumstantial evidence.
Right. So what you do as a Jewish judge in Salonika, 500 years ago, who do you turn to? What do you do? You don't have police or anything like that. You don't have executive power. What would you do? You would threat him, maybe put him in excommunication. You don't get an aliyah. The man will say, "I'm going to go by my own synagogue."
Would that really bother? I mean, would that be enough of a threat, though? If he's
it's not.
To take an oath?
Probably not. We see it with agunot all the time. People are excommunicated. They can't get drive. They don't care. So what else could we do?
Well, if there is a strong inclination, if the hunch is that this individual is guilty, I would make them repay.
How do you make him repay?
Is this because the person claiming they have no money?
No, he has the money. He has the gold. The gold is visible. They know that he has it, but he claims that he got it from someone else. How do you make him give you the money, give you the gold and silver?
We're talking about in Salonika, right? Not today.
Salonika, Ottoman Empire, 1550, something like that. Midnight Express, so this is someone that the local authorities are could be quite harsh. It's a problem. Okay, so here's the problem, right? That the rabbi sort of arrived at a verdict, but now how is he going to impose it, or how do you do the law enforcement? So he says this: "Shikre'u la'ish asher nimtza beyado." Let us summon again that man. "V'yahakeru v'yidreshu mimenu." They would have to cross-examine him. "Hadavar minayin ba." We want to know, where did you get the gold from? "V'lo yisho'eh b'divrei sheker." And he cannot use false arguments. I mean, if we don't feel that it's ta'anot hamityashvot el halev, we want something that could really satisfy us as a logical argument. Az ulai ra'ui lefotro. So he says, okay, we have to reopen the case, summon the man, and demand that he gives us logical explanation of where did you get the gold. Aval. But if his argument is going to be illogical, kegon, שיאמר מגוי לקחתי, he will say, I took it from a non-Jew, ונחזור ונשאל ממנו, so we'll ask him again, ולמה הלכת פעם אחת ופעם אחרת לאומן אחר? We'll ask him, why did you go each time to a different craftsman? ולמה לא גילית לאומן יהודי כשר שלקחת? So why didn't you tell a Jew that is reliable that you took it from a goy? You could have done it before. ודברים הרבה, and there's much more that we could do. ועל דרך שאמר שמעון בן שטח עליו השלום, he quotes Rabbi Shimon ben Shattach from Pirkei Avot, who says הווה מרבה לחקור את העדים. You have to go with your investigation very thoroughly. And he says also, v'chol sheken, even more so, Ki kala de la pasik. We have a rumor that does not stop. Everybody's talking about shezahav ze'ua nignav mibet Yehudi zeh. So here, all that, Josh, we're going back to this statement in the Aruch HaShulchan. You see, we have all the words here. Va'afilu en badavar idud gmura. We don't have a clear testimony. Ela sheyesh raglaim ladavar. But there are enough, well, let's call it like, pillars on which it stands. Vekala de la pasik. And there's an incessant rumor everybody speaks about. Then you have to do whatever is within your power, right? So what's within your power in, like I said, in 16th century Salonika? He says, "Velule havut tzaytei da'ati," and if they would follow my opinion, my verdict, lemosro beyad umot ha'olam. We should hand him over to the local police. And again, remember, this is the Ottoman Empire. It's not, you don't want to be in their jail, and you would think,
Right.
we want to protect the Jews of back then as much as possible, not to get there. What we should do, we will give him bishvil hov hakarov leshovi azahav. This is interesting. He says we would tell the non-Jews, the Ottomans, that he owes us money in the amount which is more or less the value of the gold. And that is for the same reason that I mentioned before, that the Jews were trying to keep their businesses as much as possible under the radar. So they can't say, we have this kind of gold, it's like cash. It's like the most precious cash that you can have. But rather, we will say he owes that much money. So, and that is an important statement that the Maharashtam makes, which is that maybe the only way that we could force that person to admit everything is to show him that we are determined and that we are willing to hand him over to the Ottoman authorities. So, in the same manner today, you would say that the litigants or the parties who cannot get to a resolution in a rabbinic court, or or they could get a resolution or a verdict, but one of the sides would not follow it, should go to a civil court. So this is really an interesting question, because in the Orthodox and the religious communities, for some people that seems like almost idolatry. It's either idolatry or what they call moiser, meaning an informer. By going to civil courts, you are going to cause another Jew to sit in jail, and it's like the greatest sin possible. Have you ever heard of situations like that? That people try to avoid going to a civil court because of religious grounds? Rebecca, yeah, you had that? Your mic is off.
Not necessarily for religious grounds, but trying to avoid it because of immigration status, things like that.
Okay. So, an immigration is interesting because that is sort of, that is probably the reason that originally the rabbis were reluctant to use the non-Jewish court system, not as much because of religion. I mean, they claim that it's a question of religion, it's paganism, etc. But I think it was really because we as Jews, we were second-class citizens. And the danger, the risk that you would run is that if you go to court, both sides are going to lose. And if the rabbis or the court would intervene in favor of one of the parties, that side is going to lose as well. And I'll give you one example from Rebecca. Is put the mic back off. Yeah, sorry. There was a case in Aleppo, it was in Aleppo or in Damascus. With a very famous family, the Farhi family, which the same situation where one that they didn't want to reveal the volume of their business to the authorities. So one of the brothers took an advantage. One of the brothers who really had less shares in the company took advantage of the fact that his brother died, was attacked and killed by robbers on the way from Tzfat to Lebanon, and took control of the company. And then they got entangled, and everything was done under the radar, like I said before. At a certain point, the rabbi of the city, Rabbi Avraham Entebi, tried to get involved, and the one brother who took control over the family company, the family business, had so much influence that he got the rabbis into a house arrest. So when you think about not going to the authorities, it was for them a major concern, because the authorities were bound to turn against you. They would take advantage of people. Like if they just know that you have money, they would say, okay, both of you will go to jail and we'll take the money. It was not unheard of. I mean, the Jews in Europe who were moneylenders, that was their business, and what they did in many cases, they financed the military campaigns of the local princes, usually ended up not being paid. It was more like ransom. Okay, you have money, give it to me, I need it as a loan, I need to finance my campaign. Then the campaign fails, the prince comes back home. The Jew would rather not mention that he has there's a debt, because he's going to be killed for it. So they were very reluctant to go to civil courts. But today, we live in a democratic in a country where hopefully the justice system functions more or less correctly. There are always rotten apples. There are always people who could abuse the system, but overall the judicial court works fine, and we have honest people there. So to say I'm not going there because they're pagans or because they are crooked is really a pretext to say I don't want to run my business ethically. So I'll give you one example, a real case that happened to me years ago, like 15 years ago, 16 years ago. A real estate agent was conducting was in the middle of a deal, and then at a certain point, the prospective buyer went behind her back directly to the landlord and bought the house, so she lost the commission. And that man, it was in New Jersey. The man just moved into it's a small town in New Jersey. He moved there from the city, from New York, and part of his of what happened as he moved in, he also gave a nice donation to the rabbi in the synagogue when they used it to buy a parochet, a curtain for the ark. And this woman came to me with the case. She's a real estate agent. She says this man cheated me and he took away my business. I mean, he denied me my commission. And she says, and I approached the rabbi of the synagogue where he donated like $8,000 for the parochet, and I told him that his congregant has deceived me, and he said, I'm sorry, there's nothing I could do, I cannot force him to pay you back. So what I did, I asked her if she has all the documentation, and she did. She had letters showing the agreements and the dates of when he signed the contract with her and when he purchased it directly from the landlord, which proved her that she was right. So I told her that she should really take it to court because she has all the evidence and she could get her money back. And she was almost, she was shocked because she never heard of the possibility of taking it to court. I said, no, this is the halakha. As we'll see next time, that really the Aruch HaShulchan, following previous legislators, says that not only it is allowed, but it is the obligation of the Bedin to refer people to civil court and even go themselves and testify there. And she did that, and she eventually got her money back. But unfortunately, this is something that is covered up and not known in the Orthodox world. Okay, so any questions on that? What we've discussed so far?
So